Welcome to the next edition of War Story Wednesdays. Today, I want you to pretend that you are a software engineer. And unfortunately, you don't work for Google or Twitter or Facebook. And so you don't have millions and millions of dollars, but you got a little bit of money. And you've decided that you want to get out of the rat race, that you want to get out of the Bay Area. You want to move to where things are a little calmer and a little slower. So you start looking at farm property. And you find a place that's got 30 acres. Nice little house, 13 acres of lemon trees, 15 acres of avocado trees. This is going to work just fine for you. And the fact that it's got income from the orchards helps pay for the mortgage of the house. Because after all, you didn't get an IPO and you don't have gajillions of dollars. So you strike a deal, and during your inspections, you walk the field, you walk the orchards with the owner and the real estate broker. You kind of kick a dirt clod over here because after all, you really are a city slicker. And you are not a farmer. But a couple of the trees look sickly, they look droopy, they just don't look healthy. And you ask the owner if there's any problems with the trees, and he says, nah, they're just a little waterlogged. They've been over-irrigated, and there was a rainstorm a little bit ago, so the trees just need to, dry out a little bit. Then you look at the real estate broker, and the real estate broker asks the seller if there's any evidence of root rot. And you're thinking, root rot? What the heck is that? Turns out that the real estate broker also owns an avocado orchard and knows that one of the things that can injure trees is this thing called root rot. And the seller says, nah, no, not to my knowledge, nothing like that. So you close escrow, and 30 days later, more trees start looking sickly. And you start walking around with your foreman, and it turns out about 250 of the trees suffer from root rot. And within that same 30 days, your foreman goes into the barn, and there is a 55-gallon barrel of chemicals that are designed to treat root rot. And the barrel's been there for a while. Clearly, the seller knew and didn't bother to disclose it. Now, when you bought this property, the seller carried back financing. And without 250 trees producing avocados for resale, you can't make the payments. And the seller forecloses and takes the property back. Now, that makes you a little unhappy, and you sue the broker for failure to disclose the fact that there was root rot, and you sue the seller for fraud. Now, the agent claims that there was no duty for the agent to inspect this property or to do an investigation with respect to the orchard because that's commercial property. And the agent's duty of inspection only applies to residential property. And you say, well, but wait a minute, there's a house right there. And that house required the agent to conduct a diligent visual inspection. And if the agent had walked in the barn, the agent would have seen the barrel of chemicals. So the agent breached its duty by failing to investigate. Plus, you asked the agent about the trees. And the agent said, well, no root rot. Did the agent have an obligation to investigate? That was the question that the Court of Appeal had to answer. And the answer was no, at least not as to the orchard. First, with regard to the residential property, the agent's duty is limited to the residential portion and only 4 units or less. If it's 5 units or more, there is no duty to inspect because that makes it commercial property. With regard to the commercial property, the code section that the client sued under was limited to 2079, the residential real estate duty of inspection and disclosure. It was not a suit based on breach of fiduciary duty. The court found that because there wasn't a breach of fiduciary duty claim, but only a claim based on the violation of the duty to do a diligent inspection of residential property, that the broker had no liability. The seller, of course, got paid through the nose for the fraud. The buyer made a mistake in the way that the buyer presented the lawsuit. If the buyer had sued the agent for a common law breach of fiduciary duty, I believe the buyer would have won. I believe that the buyer could have imposed liability on the broker for breaching the fiduciary duty of investigation as a buyer's representative. But because the lawsuit was presented only as a violation of the listing agent's duty under Civil Code 2079, the real estate agent got away with no liability. The counter side to that is, if the real estate agent had a duty to investigate, did the real estate agent meet that duty by asking the seller if there was any root rot? When the seller said no, did that meet the agent's duty of investigation? We'll never know, because the Court of Appeal never addressed that question. What do you learn from this one? First, get a good lawyer, because if the lawyer had pitched this claim differently, you might have won. Second, with respect to commercial property, it is important to know that the agent's duty of disclosure from an investigation under 2079 is limited only to single-family houses or 1 to 4 unit property and does not extend beyond that. So commercial property brokers get something of a pass for a duty of a diligent and visual inspection. Sort of.